Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. In this video, we are dealing with the final part in relation to law and employment. Before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. In this video, we are going to be talking about dealing with a trade dispute at the industrial court. And for purposes of this discussion, we're going to use an instance where an employer has terminated the contract of employment and the employee is aggrieved because they believe that the contract of employment was not terminated properly. When the matter has gone for mediation and there is a certificate of failure to settle issued by the mediator, the employee will file this certificate as an annexure to his application to the industrial court. This application to the industrial court has to be made by the employee within 30 days of issuance of the certificate of failure to settle. And this application is done by way of what is called a statement of case. And in this statement of case, the employee will describe themselves, they will state when they got terminated and how they got terminated, and then they will talk about how this matter went to mediation and then attach a certificate of failure to settle. They then file the statement of case with the industrial court and it has to be served on the employer also within the 30 days of issuance of the certificate of failure to settle. And then within 14 days, the employer, if they decide to oppose this application, has to file what is called a statement of defense. In the statement of defense, the employer will also tell their story. The story will be when the employee was hired by the employer, when they got terminated, what they were working as, the circumstances that led to the termination, that is the reasons for the termination, and the process that was followed for purposes of termination. The statement of defense has to then be filed and served on the employee within this 14 days after receiving the statement of case. The statement of defense is going to be served on the employee on their chosen address, which is the address that they would have put in their statement of case. And going forward after that, all court documents then have to be exchanged and served at the place that is chosen or the address that is chosen and recorded in the court papers. And the reason I say place or address is that sometimes people will put in a postal address as the place where they will receive service. This is not advisable because sometimes the papers then don't reach the necessary person for whatever reason. After the statement of defense has been filed, then the matter is called for the first time at what is called roll call. And at roll call, the judge will assign the matter to a registrar for what is called case management. And at case management, the parties will, among other things, try and settle the matter. If they are not able to settle the matter, then they will agree on the issues of dispute. They will agree on who the parties intend to call as witnesses and how many they are. And they will agree on issues that are agreed by the parties. And they'll also agree on the issues of law to be dealt with by the parties in the matter. The minute for that meeting is then prepared by the registrar, signed by the parties, then filed by the court. And in setting the matter down for this case management, The court would have also set the matter down on when the parties will appear before court after the case management meeting. When the parties go back to court, they will ask for the minute of that meeting to be made an order of court. They will then set out dates for when they will file what is called discoveries, which are the documents that they intend to use as part of the trial. And they will also set out when they intend to file what are called witness statements. And that is to give a brief overview of what each witness that the party intends to call will say, so that the other party is aware. However, because most of the time the employees at the industrial court are self-actors, that is, they don't have legal representation, the court will allow them from time to time to not have to file various documents. And then the last document that would have to be filed would be what is called a paginated bundle of pleadings. And this is where there is one bundle that is put together, usually by the applicant. But if the applicant is a self-actor, the court will say it should be prepared by the person who has legal representation. And this is the one document that will be used throughout the trial. Once the discoveries and witness statements are filed, then the paginated bundle of pleadings will contain all the pleadings that have been filed. It will contain the statement of case, the statement of defense, it will contain the minute of the meeting between the parties, it will contain the witness statements filed by both parties, as well as the discoveries. After this is done, the court then sets the matter down for trial. And the trial dates will depend on how many witnesses each party chooses to call. Sometimes each party will just call one witness. And if there's one witness, the court might decide, you know what, having looked at the papers, I'll just give you 1 day. Or I'll give you more if there are more witnesses. The witnesses then all have to come to court on the appointed days. On the first day of the trial, the applicant will open their matter. And I know I'm using the word applicant because that's how they are referred to in the industrial court. If you have watched my video where I talk about filing of actions and applications, you will then ask yourself, but Bonolo, I thought you said in applications we only file court papers and then argument, and then witnesses are only called in relation to actions started by writ of summons. Yes, that is true in the ordinary instance, but at the industrial court, it is different. The parties are called applicant and respondent, but the matter is carried on as if it was an action. So the applicant will start off their matter. They can either give evidence themselves, or they can call their witnesses to give evidence in addition to what they've already said as the applicant, and so on. Remember, everyone is entitled to representation at the industrial court, even using attorneys. During this, the applicant, let's say the applicant is the witness or one of the applicant's witnesses, they will start with what is called examination in chief. And that is where the witness tells their story. Once they finish telling their story, then the respondent or the respondent's attorney then asks this witness for the applicant questions in what is called cross-examination. And these questions are asked in order to demonstrate that what the applicant is saying is not true, or it doesn't support what they're asking for from the court. After cross-examination is done, then the applicant can do what is called re-examination or clarify certain things that need clarity after cross-examination. That is the ordinary course. However, at the industrial court, after the examination in chief, the judge and the assessors can ask questions. And that is because at the industrial court, the judge will sit to hear a matter, and they will sit with 2 assessors. The first assessor will be an assessor representing trade unions, and then the second assessor will be an assessor representing employers' organizations. Once the judge and the assessor has asked questions, then cross-examination can proceed. Or sometimes cross-examination will come first and then the judges and assessor will ask after. After all of this, then that's when we get to re-examination. Once the applicant has finished giving their testimony and their witnesses have finished, then the respondent opens their case. And they open their case by getting on the stand and giving their evidence, and it will follow the same process of examination in chief, then questions by the judges and assessors or cross-examination, and then re-examination to clarify some things. So like I said, the questions by the judges and assessors can come before or after cross-examination. But this does not mean that the judge cannot ask things for clarity throughout the giving of evidence, whether it's during examination in chief, cross-examination, or re-examination. Once this is done, every party has given their evidence, then the court will ask the parties whether they want to give oral submissions or whether they want to have written submissions and give oral submissions after that. It's up to the parties to agree. And there'll be timelines for these oral submissions or written submissions depending on what the parties have agreed. And after the submissions have been done, the court will tell the parties that they will be given a decision on a date to be given by the court. Once a decision has been made, and a decision could be either in favor of the employee or the employer, then the party who is unhappy with the decision of the industrial court has the power to appeal to the Court of Appeal. And the way that this process takes place is that they will file their notice and grounds of appeal within 6 weeks of the decision being given. And they will do so by first filing this notice and grounds of appeal and all other necessary documents if they're represented, like your power of attorney or resolution if it's a company or a non-natural person or any other entity. They will file it with the Court of Appeal and also file it with the industrial court. This has to also be served on the party who is the one who got judgment. So if we continue, if the employee is not successful at the industrial court, then the employee will be the one doing this appeal process. So they will file at the Court of Appeal and the industrial court their notice and grounds of appeal, and they will then serve these notice and grounds of appeal on the employer. The employer then has a period of 3 weeks to oppose this appeal, and the opposition has to only be filed with the Court of Appeal. It doesn't have to go to the industrial court. The registrar of the Court of Appeal will then set the matter down. And I know I'm being technical, but unfortunately, this is how this is how technical the process is. And there's nothing much I can do about that. But it's for information purposes. The registrar of the Court of Appeal will then notify the people at their chosen addresses, and this chosen address for the appellant will be that which is in the notice and grounds of appeal, and then the chosen address for the respondent will be that which is in their notice of opposition. And in that notice to these parties, the registrar will be setting the matter down to settle the record of appeal. On that time and date, the parties will appear before the registrar and agree on what forms the record of this appeal. They can decide what papers will go in and what papers will not go in, and so on. And one fundamental thing that people should never forget is if you're challenging a decision of the court, then the judgment of that court should be part of the record. Just for noting. And then after that, the registrar will also say, I'm setting a security for costs amount at, let's say, depending on the complexity of the matter, it could be 5,000, 10,000 or more. It all depends on how complex the matter is. And this security for costs is paid by the appellant. And the reason why it is given is so that if the appellant, who is the one that has dragged someone to court, is not successful, then the respondent can claim their costs from that security for costs. The registrar will also set timelines for when the security for costs will be paid, and will also tell the appellant how much they need to pay for purposes of preparing the record and the timeline for such payment. If payment is made, then the record will be prepared. It will be served on the parties together with a set down for when their appeal will be heard. And in doing so, the registrar will also tell them when they have to file heads of argument as part of the appeal before argument. The parties will file the heads of argument, and then they will serve them on each other and appear at court on the appointed date. And they will argue their appeal. The judges of appeal, and it's always 3 judges sitting in hearing of an appeal. It can be 1 judge where it is an application brought at the Court of Appeal for an appeal to be heard out of time, or for leave to appeal and so on. But here we're just dealing with where everything has been filed on time. The judges will be entitled to ask questions during argument for clarity here and there, or ask about issues of the record. And once the parties have been argued, the judges will say when judgment will come out. When judgment comes out, it will either be in favor of the appellant, who was the employee, or the respondent. However, no matter how the decision comes out, this will be finality of the matter, because this is the highest court of the land. If the appellant is successful, then they are entitled to get their security for costs back, and they are also entitled to go after the former employer for their costs in relation to their success, which costs will be taxed or agreed by the parties. If the respondent is the one that is successful, then they will just get their costs from security for costs paid by the appellant. And right, this brings us to the end of our discussion about the law and employment. I hope you got something of use in this discussion. I know it might have been long, but I hope it was very informative. And if you liked it, if you enjoyed what you heard, if you want me to continue to do more, please like, share this video, subscribe, ring the notification bell so that every time I put up a video, you get notified. Leave comments down below, because the more you engage and the more you leave comments, the more this channel reaches more people, and the more I can continue to bring you information in relation to the law. Please follow me on my Facebook at Botswana Thinking Law. Follow me on my Twitter at BW Thinking Law. And thank you for joining me. I will see you in my next video. Bye.